The journey continues. 42nd session. 41 over. We are in the 42nd session of Legal Empowerment Through Interaction lecture series. Today, we have one of the eminent faculties that could be even thought of, Dr. Kaul. He'll be addressing us today. And to present the subject, we have got even more wonderful, whom I call, or we can address as Shankaran. Over to you, Justice K.T. Shankaran,
Yes.
sir.
Yes, sir. Namaste, sir.
Namaste.
VT Kaul, sir. It is a pleasure to see you, hear you. Hey, dear friends, I met Professor, I would like to call him Professor VT Kaul. I met him for the first time in the National Judicial Academy. His speech was so much, lecture was so much impressive. I noted. I got his address. I got his telephone number. And then I could persuade him to come to Kerala Judicial Academy on three or four occasions. And one occasion I remember that he agreed to have the lecture till lunch on the subject culpable homicide and murder, differences 299, 300, 302, 304 and allied subjects for the district judges. And he continued for the whole day that subject. And that was the best in the series. And all the participants said that they had a, wonderful session. And in fact, on his request, I had gone to Delhi Judicial Academy and also the Vivekananda Institute of Professional Studies at Delhi. And on many occasions, I had also gone to his house and had breakfast, various types of dishes. I enjoyed. And that friendship and respect, I got respect towards him. He considers me as his younger brother, or I don't know what is the age difference, but I always treat myself as his younger brother. And I used to interact with him very often. And it would be a wonderful session for me. Explore all the possibilities. And sir, though this is for 1 hour, 1.5, 2 hours, sir, you need not, there need not be any constraint on time. To have knowledge, there is no constraint of time. Sir, you continue to have it to your satisfaction. And there is no time constraint. Is it not, Shyam?
Absolutely, absolutely, sir. Time is not a factor.
Time is not a factor.
We have been in this journey together, sir. I mean, all the part. Today we have 225 or 230 persons. All of them know what's happening.
So it is a pleasure, sir, to be a participant along with you in this session. I will be watching it. I will be learning. I will be joining. Thank you. Please enjoy the feast.
Thank you, sir. Over to you, sir.
Well, I'm very grateful to all of you, especially Justice Shankaran, with whom I have a long association and who has been very kind always whenever I visited Kochi. And he has been one of those very strong pillars for founding any of the institutions. And I think if this country today is doing well in many areas, it is because of the people like Justice Shankaran, Justice Nagamuthu, that who are honest, people of integrity, and people of high values, and above all, people who are experts in their subjects. In fact, I would say that I have learned quite a lot in all respects in my association with them. And whenever I get an opportunity to meet them, to interact with them, it's always to my advantage. I'm happy that we are dealing with a subject which Justice Shankaran would call me to Kerala Judicial Academy for his session judges, and it would be almost a day-long session, and we would still fall short of time. But I don't want to continue for a long time today. I would rather spend more time answering your questions, but I would certainly like to uh, let you know as to what my understanding of this subject is. I may be wrong, because learning and unlearning is a very, very continuous process. We must learn, we must unlearn. Maybe there are certain concepts which are so fastened to my mind that they need to be uh, changed, and I am open to change my concepts if I get a good feedback from you. But I must say that this is Macaulay's one of those very important contributions in the Indian Penal Code, that he has been able to scientifically draw the offenses relating to human bodies. And especially, it is my view that if a person understands the distinction between 299, 300, I think most of the IPC is done. And if this concept does not get clearer, or a person does not try to find the subtleties of these concepts, I think the study of IPC remains incomplete. Therefore, let me move in this voyage, try to learn and unlearn whatever I know about this subject, and tell you that in my understanding, offenses against human body, particularly, which I am going to talk about today, move from assault to murder. At the bottom of it, I would place, whether you use criminal force or assault, but whatever it is you liked, my understanding of the subject is you must lay down a ladder. In the ladder, you have to put at the bottom criminal assault. Above that, you put hurt. Above that, you put grievous hurt. Above that, we put culpable homicide if death has taken place. And above that, we place murder. It's a voyage from assault to murder. And I will demonstrate why I say so, because I will come to this important concept at some point of time during the course of our discussion. Now, as we will progress, we will see the importance of the subjects that I gave, these very important concepts. At the same time, I'll be using in my explanation of the various concepts under the IPC through various terms, like I'll be using the words may, possible, probable, most probable, and certain. Whether you see it in the scale of 100 or scale of 10, at the bottom I will place the word may, then I will see the word possible, then I will see the word probable or likely, then we will go to the most likely, or what you call as sufficient in the ordinary course of nature. And then we talk about certainty. Now these are concepts which, let us say, may starts with 40% or 4, a figure of 4. Possible, 5. Likely, let us say 7. Most likely we say 8. And certain we say 10. 10 is always more than 8. 8 is always more than 7. 7 is more than 5, 5 is more than 3. So this is how we have to understand criminal law. Because when you go to section 299, which defines culpable homicide, the legislature has used the word likely. So therefore the benchmark is likely, which is more than may and possible. And that is what is to be appreciated. Minimum chances of death by the act of the accused with the requisite mens rea which causes death is likely. Out of that means, if suppose this injury is given to 10 people, how many of them should die and how many of them may survive? It's a very, very important concept which we must understand. Let us look at homicide means killing of a living human being by a human being. And culpable means which is blameworthy. But all homicides are not culpable homicides. We have also homicide by rash or negligent act not amounting to culpable homicide. So that is what we must keep in mind. Now, culpable homicide is defined in section 299. And every inquiry where the act of the accused produces death, death is the cause of the act of the accused, and I defined what is act. If you look at the definition of the act, act means a single act and includes plurality of acts. Act also includes illegal omission and also includes plurality of illegal omissions. And that is the definition which is given in IPC itself, which I don't have to read every part of it, but section 32-33 will bring that concept very clearly, that act includes series of acts, includes an illegal omission, and includes series of illegal omissions. But have a look at section 299. As I said, actus non facit reum nisi mens rea is the basic principle of criminal liability. No act per se is criminal unless accompanied by guilty mind. And in IPC, we have every offense has internalized this concept of actus non facit reum nisi mens rea. In 299, it says whoever. Now, whoever, the term is human being. Now, the agency could be any agency, it could be animal also, a snake bite, anything. But whoever causes death. Now, this is a very important concept. There has to be Newton's laws of motion in operation. There has to be a cause and effect, and the cause must be the direct cause, not the remote cause. The act of the accused, whoever causes death by doing an act with intention of causing death. You must have the intention to cause death. You must do an act which is giving effect to the intention and produce the desired consequence. It is very important at this stage to make a distinction between motive, intention, and knowledge. Because when we go to class 3, which we will follow, because class 2 says with intention to cause such bodily injury as is likely to cause death. And third says with the knowledge that he is likely by such act to cause death. Now, death is defined in IPC itself. You don't have to go anywhere. You will find the definition of death also, which is in 46. Which says, unless the context requires otherwise, Death means death of a living human being, death of a human being. So therefore, when it says whoever causes death means causes death of a human being by doing an act with intention to cause death or with intention to cause such bodily injury, likely is very important, or with the knowledge that he is likely by such act to cause death. Again, the word is likely. Now, this brings us to a very important concept. What is the distinction between motive, intention, and knowledge? Now, motive is not an essential element of an offense, of any offense, generally speaking. Because some of you may say later on, when you go to 141, common object, you have an unlawful assembly, 5 or more persons constituting an unlawful assembly, where we talk about common object. But that I'm not dealing with, I'm talking about motive. Motive is something which prompts you to form an intention. Motive can be good, motive can be bad. Like, migrant workers walking on the roads across the country do not have a food to eat, and the child is starving, and a father cannot see his child starving. Therefore, cuts some fruits from the tree of another person which belongs to somebody else. Now, to feed his child, he may commit theft, form a dishonest intention, form a bad intention. Similarly, with respect to bodily offenses, intention is a design which is in the mind, motive is something which is behind the mind. Now, that is one of the ways of explaining it. What is behind the mind is motive. And motive prompts you to form an intention which is within the mind. And knowledge is the awareness of the consequences. As I said the other day, law presumes everybody to be a sane person. Law presumes everybody to be a prudent person. And you ought to know the consequence of your act. You can't say, I do not know the human anatomy. And if you read Virsa Singh's case, a very beautiful case, people cannot say, I did not know where the kidney of a person is, where the spine of a person is, where the heart of a person is. Therefore, had I known it, I would not have given a blow. Some knowledge of the human anatomy is attributed to every person. And everybody is attributed some knowledge. And that knowledge of the consequence is what we call as mens rea, in the form of knowledge of the. Now, I'm sorry, I think it was a muted part. It had got muted. I just wanted to again bring in. Motive is something which is behind the mind. Intention is something which is within the mind. Knowledge is something which is attributed to everybody. And everybody is presumed to be sane and a prudent person with some amount of knowledge which everybody must have. So kindly be very clear when we say class A, B, C up to 99 talks about 3 situations where the act of an accused can amount to culpable homicide. What is culpable homicide? First sine qua non is death must happen. And death must happen by the act of the accused. And the act of the accused must be accompanied by guilty mind, either intention to kill or intention to cause bodily injury, or even if there is no intention to kill, intention to cause bodily injury, there is Knowledge which can be attributed to the person and what is the degree of knowledge, that is important. So when we say A wanted to kill B, he must do an act which will produce death. And if death results, it is a case which is falling in class A of section 299 and is culpable homicide. So where you intend, whatever may be the motive is not an essential ingredient, but is a very important element for the prosecution or for the investigator to find the intent of a person. In every case, the first thing that we try to find out is the motive behind the crime, because that will lead you to know the intent of a person. And intent is a design which you want to accomplish by doing an act and producing a forbidden consequence in the form of a death. When Nathuram Godse did 1, 2, 3 to Gandhiji, the intention of Nathuram Godse was very clear. If you put a house on fire and prevent the people to come to the rescue of the person whom you want to kill inside the house by burning him by fire, your intent is very clear. You intended to kill him, and if he is killed by burning, one of the famous cases of the Supreme Court, where Supreme Court said motive of this man was the rivalry, and then the intention was very clear from his act, and it was a case which we always say is the case State of Hyderabad versus I'm not getting that case here, but I'll come back to that case on something. That was a case where the person, in order to ensure the death of a person, put the house on fire and did not prevented the people from coming to his rescue, and the person was burned alive. And the court said it is very clear case of falling into 299A. You can't get simple cases like this. So we don't generally deal with class A as such, because class A is the most simplest form to find, to illustrate the culpable homicide. But problems arise when we go to class 2 and class 3. Now, class 2 is very important from the point of view, what is the distinction between A and B? And that is where now I will also take you to something which is not written in books, which is not written in the cases decided by even Supreme Court, but something which, unless it happens, you read it like 299 like that, you cannot go to section 300. You see, in the scheme of the IPC, 299 has 3 classes, A, B, C. And all 3 are alternate classes, all 3 constitute culpable homicide. And all 3 have comparable clauses in section 300. Now the comparable clauses are, A is 1. There is no A, B, C in 299, but you have to assume it in your mind. We put A as with intention to cause death. Whoever causes death by doing an act with intention to cause death, that is class A. If you can put 299 on the screen, can you put it? Can you put 299 on screen?
So just give me a second.
299.
Yeah. So it's not working. Can I just read that provision?
Anyway, I'll read it myself.
Okay.
You see, there is no A, B, C. In 299, they are or. But you have to read A, B, C. First class, whoever causes death by doing an act, you can now say A, with intention to cause death, or B, with intention to cause such bodily injury as is likely to cause death, or with the knowledge that the act is likely to cause death. These are three alternate clauses. And I will demonstrate to you all the three and explain to you all the three. What falls in B and C will always fall in A. But what falls in B and C will not fall in A. That is why we'll see alternate clauses, why they are. It is the expansion of the definition of culpable. First is
Sir, your voice is breaking. Sir, your
Voice is breaking.
Voice is breaking.
To kill act causes death because you have the intent to kill. Death results. Now kindly see, there is no A. Yes. So, hello.
Yes, sir.
Hello. Can you get me?
Yeah.
Hello.
Sir.
Can you get me?
Yes, sir.
Am I clear? Am I clear now?
Absolutely, sir.
Now kindly see 299. Whoever causes death by doing an act. Now put A there with intention to cause death, or B with intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death. Now this is very, very important. Now why I say this? Now come to section 300. Can we go to section 300?
Sure, sir. 1 second, sir.
Can we go to section 300?
Sure, sir. Sure, sir.
Or what you can do you have that Punnaya's case with you?
Sir, that has already been circulated, sir. 1 second, sir.
Mr. Shyam?
That is on screen.
Okay.
So it's on screen. Can you see, sir?
Now look at this. Yeah, kindly see. Forget about this part, except in cases I'll come to that. If the act by which death is caused is done with the intention of causing death, it is exactly the same as clause A of section 299. So comparable clauses I am just trying to make. Now 2 and 3, secondly and thirdly are very important because they are. Now it says if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Or if it is done with the intention of causing such bodily injury to a person and the bodily injury intended is sufficient in the ordinary course of nature to cause death. Now I will, and fourthly is comparable with clause C. Knowledge that the act is likely to cause death. If the person committing the act knows, because there is no intention here, that it is so imminently dangerous, this must in all probability cause death or such bodily is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such bodily injury as aforesaid. Now let me come to what I wanted to talk to you. I wanted to talk to you that clause 2 section 299 has 3 clauses. One is the clause where there is clear and death results, it is culpable homicide. And also is murder within the meaning of first, except if you falls in any of the exceptions, because it says act done with which the death is caused with the intention of causing death. Therefore, A and 1 are same. There is no difference in the two. Except that when a case falls in 299, also falls in 300, you still have to go to the exceptions, whether it falls in any of the exceptions. When we say what is murder and what is culpable homicide, let me be very clear on that. We say murder is where a case falls in 299, where it falls in 300, and does not fall in any of the exceptions to section 300. What is culpable homicide not amounting to murder is where it falls in 299 but does not fall in 300, or it falls in 299, falls in 300, and also falls in any of the exceptions to section 300. Two ways where the act of a person can amount to culpable homicide not amounting to murder. Only one way of reaching the conclusion is 299, yes, 300, yes, but this also falls in one of the exceptions to section 300. Now that is how we look at it. Now let me go. Let me go to the comparison. Let us go to class B of section 299. That is very important for me. Now here it is not talking about intention to kill. In 299, let us go to 299. Yeah, 299. Yes.
So can you see 29? Is it on the screen?
Yeah, now it is green. Yes. Now it says with the intention of causing such bodily injury as is likely to cause. Now you must have the intention to cause the bodily injury which is present on the body of the deceased. It must not be accidental or unintentional. Like suppose you want to give a injury on the thigh region, but it lands in the abdominal region. You want to give an injury on the shoulder region, but it lands in the heart region. It is not the intended bodily injury. It must be an injury which is present on the body of the deceased, and this bodily injury must be intended bodily injury. And this injury, irrespective of what the accused thought of it, independent of his knowledge, must, when objectively analyzed, is likely to cause death. Now that is where I bring that scale of 10.
Voice breaking.
Sir, the sound is breaking.
Because if it is may, it is not culpable homicide, even if death has resulted. If it is possible, it is not culpable homicide. Am I clear, or is my
The sound is a bit breaking, sir, but still you're audible. Yeah.
Mr. Sham, am I clear?
Yes, sir. The sound is a bit breaking.
Hello?
Sir, can you hear me?
There's a slight drag for the sound.
Sir, can you hear us?
Yeah, I am only trying to say.
Sir, there is a drag.
Sound is breaking.
As Ramkumar said, there is a drag.
I can
on
hear
your
you.
side.
Just
No issues, sir. No issues, please.
Again, the artist came back.
That of course. That of course.
See, in the academy when he had lecture,
Yes, sir.
I
yeah.
have noticed.
I'm just. Are you getting me now? Am I clear? This is the wear and tear.
Sir, yeah, of course.
Hello.
Yes,
Can you hear me?
Yes, sir.
No, not yet.
till the drag is there. Drag.
Hmm?
Slight drag is there.
Video.
It doesn't look like real time. That's the only thing.
We are in virtual field.
Experiencing poor connection.
Sir, I think he'll be able to fix it in no time.
Yeah, I had noticed
Yes, sir.
various voice modulations on the side of PT code. I've identified 6 types.
Hello, can you hear me now?
Yes, sir.
Huh?
But
Yes.
we
Is
can't
it-
see you, sir.
Huh?
But we can't see you.
No, I'll come back. Can you hear me now?
Yeah, wonderful. We can
Huh?
see and hear you, sir.
Okay, okay. You see, what I was saying is this. This is why main concepts I just want to clarify, because when we go to class 2, it is divisible into 2 parts. One is subjective of the offender. Second is an objective test. With intention to cause such bodily injury. Means look at the body of the disease, whether this injury which is present on the body of the disease was the intended bodily injury or not. Was it that he intended to cause this injury or not is important. And if yes, forget about the accused and see whether it is likely to cause death or not. Not that whether accused wanted it to be likely to cause death. Am I clear to you or not? Are you getting my voice or not?
Absolutely, sir. No issues.
You see, I am saying 2 parts of the section 299B is injury on the body of the deceased. See the body of the accused, deceased. Body of the deceased, the injury of the on the body. Yes. Is this the injury that the accused wanted to cause? Yes. And now objectively whether it is likely. Culpable homicide even if death has taken place. If yes, now what is the part of the body is attacked? What is the weapon used? What is the nature of the injury? How deep is the injury? Now these are all factors which will go into making whether it is likely or it is not likely. Now let me go to only one aspect. There is an explanation appended to section 290.
Again breaking in between.
A person who causes bodily injury. Now this is where I have to tell you something which you will not find in any of the judgments of the Supreme Court. A person who causes, go to the explanation 1. A person who causes bodily injury to another who is laboring under a disorder, disease. Have you got it? Explanation 1.
So 1 second. Let me see.
I'll read it out. Let me read it. A person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that person, shall be deemed to have caused his death. Now let me say what I am trying to say here, because every judgment of the Supreme Court says before you go to section 300, section 299 must apply. Section 299 must be attracted. Now I take 3 cases. Here that is where I want to take 3 cases. A case of a person of normal health and a case of a person of an abnormal health not to the knowledge of the accused. Mr. Sham, are you getting me?
Yes, sir.
3 cases I am taking, and this is where I want your views, all of you who are attending this program, and I'm sure most of you are experts in criminal law. I want to educate myself. Is this a case before it falls in 300 must first fall in 299, and therefore if a case has to be tested under 219 300 subclass 2, it has also to fall in 299. And how can it fall in 299? Now let me demonstrate how it can fall. There are two kinds of people. One is a person who is a person of normal health, another is a person of abnormal health. And abnormal health to the knowledge of the accused and not to the knowledge of the accused. A person is suffering of heart ailment, accused does not know it. A person is suffering of an enlarged liver, accused does not know it. And a person is suffering of an enlarged spleen, the accused does not know it. But other cases where the accused knows it. Now what will happen? A person of normal health and a person of abnormal health, not to the knowledge of the accused, have to be tested on the annuals of what is the effect of this injury on a person of normal health. Justice Ramkumar, please appreciate this point because this is not talked about in any of the judgments.
Very well said. Very well said.
Who, to the knowledge of the accused, is suffering of a bodily infirmity, therefore impact of the act is to be seen with respect to the people of abnormal health. What may be possible in case of normal health may be likely in case of abnormal health. Now, the point that I am trying to make is, since the categories change, therefore likely in third case is different from the likely in first two cases. And that is visible when you go to section 300.
Clause 2.
Clause 2 talks about two kinds of knowledges. Second is knowledge of the fact. Have a look at 300 subclause 2. And this is where I want you to kindly test this proposition. How does a case fall in clause 2 if it does not fall in 299? It falls if you read a harmonious construction of 299 and 300. This class, but if they come to the case, the best way to deal with them is as I will suggest to you. If it is done with the intention of causing such bodily injury as the offender knows is likely to cause the death of the person to whom the harm is caused, it is individual specific.
Particularized.
It is individual specific. It is not an objective inquiry as we make it when we'll go to clause thirdly. It may not be likely to cause B's death, but it is likely to cause A's death because what happened to it? Because A is suffering of a specific bodily injury to the knowledge of the accused. Am I clear on that proposition or not? Three cases that I take, and these three cases you have to see in 299B itself. 299B, you have to conceive three cases. One is a case of a normal health. There is no problem in those cases. Then you have to conceive of a case of an abnormal health, not to the knowledge of the accused. And then you have to conceive case of an abnormal health to the knowledge of the accused. First two to be tested with reference to the people of normal health. And second, third case to be tested with respect to the people of abnormal health. First two cases will be comparable in clause thirdly, and last case will be compared in clause secondly. This is by reading explanation 1 along with clause B of section 299. Now kindly see, that is what is very, very important for us to understand. is a person who causes bodily injury to another who is laboring under such disorder, disease or bodily infirmity, and thereby accelerates the death of other person shall be. Why I say you have to impute, you have to bring in implicit knowledge. And that is when you bring in then clause B of 299 and clause 2 of section 300 are comparable clauses. Every case which falls in clause B of 299 read with explanation 1 and implicit knowledge is comparable in clause B, clause 2 of section 300. Leaving that point aside, now let us go to clause 299B and 300 subclause thirdly. And that is Virsa Singh's case. And that is Punaya's case. Those are two landmark cases which I think I have them, and I do not know whether you have a copy of those judgments, but there are beautiful things which I want to read out from
Justice Vivian Bose.
299, 2-3 things which are very important from Virsa Singh's case, which I want. 299B says, with the intention to cause such bodily injury as is likely to cause death. But 300 subclause 2 says, if it is done, and that's where the distinction has to be appreciated. And that is where Justice Bose, Vivian Bose in Virsa Singh's case says, 300 thirdly has to be read disjunctively, not conjunctively. The other day I said section 80 has to be read conjunctively, not disjunctively. You have to read them. Today you have to see that if it is done with the intention of causing bodily injury to any person, and the intended bodily injury is sufficient to cause death in the ordinary course of nature. And this is where Virsa Singh comes in. The argument, this was a case where one spear thrust in the abdominal region, one spear thrust in the abdominal region. The intensity was that when the spear was taken out, it brought out 3 coils of intestines. And out of those wounds was oozing the undigested food. The argument of the prosecution was, and that is what I would like you to see from this case, and a beautiful judgment that you must always, every time when you deal with this class, refer to. It was argued that the facts set out above do not disclose an offense of murder because prosecution has not proved that there was an intention to inflict a bodily injury that was sufficient to cause death in the ordinary course of nature. It was said that the only to the bodily injury inflicted, but also to the class and bodily injury inflicted. The bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. This is a favorite argument in this kind of case, but is fallacious. But is fallacious. If there is an intention to inflict an injury that is sufficient to cause death in the ordinary course of nature, then the intention is to kill. In that event, thirdly would be unnecessary because the act would, if the act by which death is caused is done with the causes are disjunctive and separate. Now this is the most important part of Virsa Singh's judgment. And the second is a pure objective inquiry independent of the offender. And the four principles that the court has laid down. Look at the body of the deceased. Is there a bodily injury? And therefore it is an objective inquiry. You just have to look at the bodily injury. It is an objective inquiry. Then you have to see how serious the inquiry is. Also an objective inquiry. Then you have to see this injury which is present on the body of the deceased and is a serious injury. Was it intended by the accused to cause it? This is subjective of the offender, pure subjective inquiry. Prosecution to prove. But then, court says, how do you prove whether it was intended bodily injury or not? The best way is, was it accidental or unintentional? You have to prove. Say, I wanted to give this part of the body, but it landed in this part of the body. But if there is no justification coming, it is that it was intended bodily injury. Please be very clear on that. Says, and I will just draw your attention to that very, very important para. The status of locus classicus. It has become celebrated law of the land. Without any exception. The court says, to put it shortly, the prosecution must prove the following facts before it can bring a case under section 300 thirdly. First, it must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. These are pure objective investigations. Third, it must be proved that there was an intention to inflict that particular bodily injury. That is to say, it was not accidental or unintentional, or that some other kind of injury was intended. Once these three present, the inquiry proceeds further. And what is that inquiry? Once these three elements are present, the fourth inquiry proceeds further. And fourthly, now this is very important. As the court said, these are disjunctive. And what is that? It must be proved that the injury in the type just described, made up of the three elements set out above, is sufficient in the ordinary course of nature to cause death. And inferential and has nothing to do with the intention of the accused. Now, sufficient to cause death in the ordinary course of nature, a purely objective inquiry. How do we do that? Look at the body, part of the body attacked. Look at the nature of the weapon. Look at the medical report. And if you have to go what a medical report should be, you have to go to state of Andhra Pradesh versus R. Punnaya. I will read out that judgment. That para of the judgment. It's very beautiful. But let me first be through with this case, that is Virsa Singh's case. The court says, once the intention to cause bodily injury actually found to be present is proved, the rest of the inquiry is purely objective. And the only question is whether, as a matter of purely objective inference, injury is sufficient in the ordinary course of nature to cause death. No one has a license to go around. Now, this is a beautiful part of it. That inflicting injuries that are sufficient in the ordinary course of nature to cause death and claim that he is not guilty of murder. If they inflict injuries of that kind, they must face the consequence. They can escape, only escape if they can show or reasonably deduce that injury was accidental or otherwise
unintentional.
Now, I said, how do we make a distinction between 299 says likely, 303 says sufficient in the ordinary course of nature to cause death? That's what I said. In the scale of 10, you have may, possible, likely, most likely, or sufficient in the ordinary course of nature. That's why we say every murder is a culpable homicide, but every culpable homicide is not murder, because it is the degree of the probability ensuring that makes the distinction between what is murder and what is culpable homicide. If the degree of probability is only likely, if the chances of death are only 60%, but if the chances of death are 80% to 99%, most likely death should happen in the ordinary course of nature. Miracles can happen. Some people can be saved. Degree of probability, higher degree of probability is the yardstick when we deal with section 299, 300 distinction, especially when we go to class B of section 299 and class 3 of section 300. Another important aspect that I just want to read out. A very, very beautiful explanation. Once the intention is established, the rest of the matter of objective determination from the medical and other evidence about the nature and seriousness of the injury. That's what I said. You have to see nature of the injury, weapon use, part of the body attack, number of blows given, all these cases. One and another important aspect that I just wanted to take up. How do we say what is the yardstick to be applied on the question of knowledge of a person? And that is a beautiful part dealt with by Justice Vivian Bose in this case only. It says, the inquiry has to be, the inquiry is the question so far as the intention is concerned is not whether he intended to kill or intended to inflict an injury of a particular degree of seriousness, but whether he intended to inflict the injury in question. And once the existence of the injury is proved, the question of cause of it will be presumed unless the evidence or the circumstances warrant an opposite conclusion. But whether the intention is there or not is one of fact and not of law. Whether the wound is serious or otherwise, and if serious, how serious, is totally separate and distinct and has nothing to do with the question whether the prisoner intended to inflict injury in question. Now, these are very, very important questions which I just wanted to draw your attention to. And these are some basic things that I want to say. In considering whether the question was to inflict the injury found to have been inflicted, the question necessarily proceeds on the broad example whether there was an intention to strike at a vital or a dangerous spot, whether with sufficient force to cause the kind of injury found to have been inflicted. It is of course not necessary to inquire into every last detail. For instance, whether the prisoner intended to have the bowels to fall out, or whether he intended to penetrate the liver or kidney or heart. Otherwise, a man who has no knowledge of anatomy could never be convicted, for if he has not knowledge that there is a heart or a kidney or a bowel, he cannot be said to have intended to cause an injury. Once that is not of course, that is not the kind of an inquiry. It's a broad-based, simple, and based on common sense. The kind of inquiry is 12 good men and true could reasonably appreciate and understand. How can you give better way of answering the questions 99B and section 300 subclass 3 other than how Justice Vivian Bose deals with it. Everybody has to be attributed with some knowledge. And that's why we say jury. What was jury? Common sense. People, normal intelligence. And these people, how they would assess the injury, keeping in mind. Just to give you idea about how the doctors should act is what Punaya's case, which is another celebrated case on this. The best person to speak, I'm talking about medical evidence. The best person to speak about the hemorrhage and cause of death. Now, this was a case where there were 19 blows given in arms and legs. And the argument was no blow was given on a vital part of the body. But the court said, even if they are non-vital parts of the body, when you take the injuries cumulatively, they can be sufficient to cause death in the ordinary course of nature. And what should you look at that stage? Is the credible evidence of the doctor. The best person to speak about the hemorrhage and cause of death was Dr. Sarojini, who conducted the autopsy. She testified the cause of the death of the deceased was shock and hemorrhage due to multiple injuries. The categorical opinion of the doctor was not assailed in cross-examination. And she had opined that these injuries cumulatively are sufficient to cause death in the ordinary course of nature. And that is why I think it's very important for us to understand how the court deals with it. Then the court says, this takes us to the testimony of injuries who said injuries of the deceased were cumulatively sufficient in the ordinary course of nature to cause death. In her opinion, now this is very important for us as a students of law dealing with criminal matters. In her opinion, which we have found to be entirely trustworthy, when the opinion of the expert becomes the opinion of the court. The cause of the death was shock and hemorrhage due to multiple injuries. Dr. Sarojini had conducted the post-mortem examination of the dead body. She had dissected the body and examined the injuries to the internal organs. She was therefore the best informed expert who could opine with authority as to the cause of death and as to the sufficiency or otherwise of the injuries for which the death ensued. Dr. Sarojini's evidence was in full credence by the court and it became the opinion of the court. That is what I just wanted to say on the question of comparison of section 299B with section 302 and section 303. Now let me come quickly to 299C. Now section 299C neither talks about intention to kill nor talks about intention to cause bodily injury. It only talks about the knowledge of the likely consequence. You may not have an intention to kill. You may not have an intention to cause bodily injury. But can you be attributed with the knowledge of the likely consequences sufficient to bring the case under culpable homicide definition? That's why we say culpable homicide is the genus, and the culpable homicide amount
Murder. Species.
And there are 3 forms of culpable homicide we talk about. 3 degrees of culpable homicide. First degree is 300, punishable under 302. Highest degree, where death can be the punishment in rare of rarest cases. Second degree of culpable homicide is 304 part 1.
Intention.
where it deals with intention to cause death or intention to cause bodily injury. Then we have culpable homicide of third degree. And culpable homicide of third degree we talk about where we deal with knowledge of the likely consequence. Now let me take this case and take it also along with 304th. And I will explain it. A person who is a snake charmer, he makes his living by playing tricks on the people. By his snakes, plays some tricks. Over the period of time, he becomes very confident and he has a snake whose fangs he has not removed. And he calls one of the spectators and wants to play a game on his hand. And in the process, the snake bites, the man dies. He has no intention to kill. He has no intention to cause bodily injury. But as a prudent person, he ought to have known snake is an animal. And if it bites the person, he is likely to die. And if a person dies, it is culpable homicide. But let me take exactly 3 cases. 3 cases, mother, child. In one case, the mother has a child, 6 months old child. And she lives almost around the place where her parents also live. Maybe about 1 kilometer or 2 kilometers away. And she wanted to visit her family, meet her parents, but her husband is a very cruel husband. He doesn't allow her to go and is, come on. One day when he's asleep, this lady picks up her child whom she wants to show to her parents that they have not seen her, this child. So she very quickly runs towards the place of her father. But this husband wakes up and he finds the child and mother missing. So he knows that they must have gone towards the place of her father. And when she hears the shouts, she looks at it and she finds, when she looks back, she finds her husband following her and following her in a very, she becomes panicky. And she, in that panic, finds a well nearby. She jumps into the well. Child was in her lap. Child dies, mother survives. Second illustration. Same lady has a child tied to the back. Because of the panic, unmindful of the presence of the child, jumps into the well, child dies, mother survives. Third, mother who is ill-treated by her in-laws. She one day announces openly in the house that you have been jump into the well along with the children. She jumps into the well along. Children die. Mother survives. Now 3 cases, kindly look at 3 cases. Keep these 3 cases in mind. 1, mother with a child in her lap Because of the panic created by her husband, jumps into the well, child dies. Mother survives. Second case, mother tied the child to the back. Momentarily unaware about the presence of the child, jumps into the well, child dies, mother survives. Third case, mother knowingly threatens to jump into the well along with the children and children die. Children die by the act of the mother. Now, in two of the cases, knows presence of the children and therefore children knowledge can be attributed to her. In second case, the third case, mother may be momentarily not aware about the presence of the child, yet had she cared to know, she would have come to know that there is a child tied to the back. As a prudent mother, she should not have jumped into the well in these circumstances. Now let me take three situations. 299B, 300 clause fourthly, 304A. Just because I am dealing with these three cases, let me momentarily take 304A also. 304A says, death caused by rash or negligent act not amounting to culpable homicide. Now, 299B says, with the knowledge that he is likely by such act to may not have the intention to kill. Mother may not have the intention to cause bodily injury. But as a prudent mother, and she is expected to be a prudent person, she ought to have known that if she jumps into the well, child is likely to die. And if the child dies, it is a case of a culpable homicide. Now let us go further and compare it with 304.3. Now kindly look at 300 clause 4.3, which also deals only with knowledge. That is why it becomes comparable clause of section 299C. Section 299C deals with knowledge, only knowledge as a likely consequence, but section 304.3 is not satisfied only with likely, but it has many more superlatives. You can see many more adjectives talked about in clause 4.3. Have a look at it. If the person committing the act knows that so imminently dangerous that it must
All probability.
cause the death of such or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such bodily injury as aforesaid. I have given you two cases, Darajia and Gyarsi Bhai. One is of the Allahabad High Court, another is of the Madhya Bharat. Very beautiful cases to explain all these three cases, and these illustrations which I have given you are actually the decided cases. And I want to illustrate these cases through the help of these cases. I want to illustrate the distinction between 299C and 300 clause 4.3. I will take the first case. Court said, no doubt the case of the mother with her child in the lap jumping into the well and not only likely, it is imminently dangerous and in all probability likely to cause the death of the child. But Clause fourthly has also another equally important ingredient which the prosecution has to prove. Now, this is not an exception. This is a part of the essential elements of the offense. And if you look at and
Without incurring the risk.
and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Now, was there any excuse? Now, this excuse is neither general exception nor partial defense. This is an excuse which is an essential element of the offense. It may be imminently dangerous. It may all probability cause the death of the child. But did the mother have any excuse? The court said she was
Chased by the
she was in a panicky state, though she was sane, though she was expected to be prudent. But put yourself in her position. Who was cruel always to his wife. She had left without his knowledge, and now he was catching her red-handed, moving out of the house without his consent. Evil to jump into the well than the evil of facing the wrath of her husband. And in that panicky state, any mind, if you put any person, he would have perhaps done the same thing or could have been driven to doing the same thing. Therefore, it may not be a legal excuse, but there was nonetheless. Therefore, in that eventuality, this part is not present. It becomes culpable homicide, not amounting to murder. But the mother who announced she is going to jump into the well, she was not in a panicky state. So therefore, she had no excuse for incurring the risk of causing the death of the children. Therefore, her case was culpable homicide amounting to murder. And the third case, which is a case of a Bombay High Court, referred to in both the cases. Court said no intention, no knowledge of the likely consequence, yet this was a case where had she cared to know, she would have come to know that the child was tied to the back, and it was a case where she was punished under section 304A. Therefore, same consequence in all the three cases. But all the three cases having three different. That is where you have to make the distinction between 4A, another is 304 part 2, third is another is 302, which is murder punishable under Indian 302 Indian Penal Code. Now, I just wanted to also further take you to one of the very famous cases and good cases that I could talk about is from Kerala only, and that case is I just want to talk to you how the judges commit the mistakes and how we do not deal with cases the way they should be dealt. I am taking only two cases. Two cases which I have given is this is Cheryobin Gregory versus State of Bihar, very famous case. AIR 1964, Supreme Court 205. And there is a case called E.K. I want to take these two cases to tell you how judges have closed minds while dealing with clause C and clause 4th of section 3C of 299 and 4 of section 300. Now, there was a case, I'm going first to the Cherubin Gregory's case. In most of the law schools, we are taught this case as illustrative of section 304A. But I submit, this is not a case of 304A. This can at least be punishable under section 304 part 2. How? Now let me say how I say this case. A person, olden days you had a lavatory which you would keep outside the house, and it would be around nearer to the boundary of the house. There was heavy rains, the walls gave way, and this lavatory of this person became exposed to the public, and naturally people started using it. He tried to warn people not to use his lavatory, but it would not have any effect. Therefore, one day he put a high charge live wire. Now, please appreciate what I am trying to say. He put a high voltage live wire and tied it and lit a bulb which was burning to tell the people that this is a live wire and do not enter the lavatory. And yet people did not stop and they started using the lavatory. A lady, while coming out of the lavatory, her hand fell on this live wire, died. This person was put on trial under section 304 part 2. Charges were framed, but the session judge acquitted him of 304 part 2, convicted him of 304A. State did not go in appeal to the High Court. He went in appeal to the High Court. From there he went to the Supreme Court, and Supreme Court was called upon only to decide the legality of the decision of the trial court with respect to section 304A. But if state had gone in appeal, the scale that is set may, possible, likely. Now this was a case of a likely to cause death. And this was a case where knowledge could be attributed to this person. And you will see that beautiful thing about Macaulay is when he says 304 part 1 and part 2. In 304 part 2 he says, with the knowledge that the act is likely to cause death, but without any intention to cause death or intention to cause such bodily injury as is likely to cause death. So therefore, this was where the trial court did not appreciate the likeliness of the consequence resulting by the act of the accused, and therefore this case could not be tried the way it should have been tried. And the second case that I want to take up is the case that has come from your state only. Judges in Supreme Court found themselves in a very difficult situation. I am talking about this case and quoting the Supreme Court, and I'll come to the facts of this case. Methyl alcohol being used in place of the permitted spirits, because people during Unam days, festival, they wanted to make quick money at the cost of the human lives. How many people died? 77. After consuming liquor from the shops and sub-shops which were catered by the firm called BV Liquors and Law. 77 people. And what was the quantity of methyl alcohol being used? Samples were sent for examination, revealed that some of the barrels contained methyl alcohol ranging from 67% to 96%. In the house of the accused 9, 3 loaded barrels were found contained methyl alcohol from 88% to 95%. That methyl alcohol is a virtual poison. Now that is what was mixed with water and was supplied to the people, and people died, and the charge was under 302. But the trial court did not find this charge sustainable, did not punish under 302. The High Court also did not punish under 302, but punished under 326. And the Supreme Court, when the appeal goes to the Supreme Court says, we are addressing, before examining this aspect, it may be stated, High Court also has not convicted any of the appellants under 302 of the Indian Penal Code, as there is no appeal to this court by the state against the acquittal under 302, we are not addressing ourselves, as it is not open to us to do so, to the question whether the appellants were guilty under 302. We are therefore proposing to continue our discussion on the conviction as awarded by the High Court. Now, but what the court did was just to do justice in the matter. The only thing that was available to the Supreme Court was to issue notice for enhancement of the punishment. And they gave the notice for enhancing the punishment. And the Supreme Court finally gave to even a person of 70 years, 74 years old person, life imprisonment under section 326. Now these are cases because of the mental blocks that the judges have and also the lawyers have, that not bring, I think these cases are fit cases where we can talk about clause C of section 299 and clause fourthly of section 300 and punish them under section 302. Now I just want to tell you the scheme as we have in. Now the court has very beautifully said, I think the last time Justice Nagamuthu was there, I do not know whether he has joined today or not, but Justice Nagamuthu said he would like the case first to go to exceptions. See the case under the exceptions. I think that is not acceptable to me.
It is not.
Because the best place to start your inquiry is 299. Because from 299, you can still go to 304A. You can still go to 325. And as I said earlier, every murder involves culpable homicide. Every culpable homicide involves grievous hurt. Every grievous hurt involves hurt, and every hurt involves assault. But every assault is not a hurt. Every hurt is not a grievous hurt. Every grievous hurt is not culpable homicide, and every culpable homicide is not murder. So therefore, you must, in each case, examine. That is what Supreme Court says in State of Andhra Pradesh versus R. Punnaya, and that is what I want to read out to you. It emerges that whenever a court is confronted with the question whether the offense is murder or culpable homicide not amounting to murder, on the facts of a case, it will be convenient for it to approach the problem in 3 stages. Now, what are those 3 stages? Stage would be whether the accused has done an act by doing which he has caused the death of another. That's what I said, causation. Whoever causes death, death must result, and death must result by the act of the accused, and accused has to be identified. Proof of such causal connection between the act of the accused and the death. Causal connection between the act of the accused and the death is the first stage. If you are not able to build up that causal connection, second stage will not come. You have to identify the accused, you have to identify the act of the accused, you have to identify the causal factor, you have to identify the cause of the death. It must be the direct cause of the death. It must not be the remote cause of the death. Proof of such causal connection between the act of the accused and death leads to the second stage. Now that is the second stage. For considering whether that act of the accused amounts to culpable homicide as defined in section 299. If it is not 299, you can go back to 304A, you can go back to 325, you can go back still to voluntarily causing of hurt, you can go to anywhere, you have every world open available to you to examine. But inquiry must start from 299. If the answer to this question is prima facie found to be affirmative. Now, this is very important. First, causal connection, death and the act of the accused. Second, whether the case falls in 299, which clause of 299 it falls, prima facie. Then you will compare it with the corresponding clause of section 300. That is very important to identify which clause of 299. Now that is why I said clause 2. For inquiry under clause 2 of 300, you have to first say it is a case which falls in 299B. Read with explanation 1, implicit knowledge has to be attributed to the person. If the answer to this question is prima facie and affirmative, you see how scientific the inquiry has to remain. This has to be a very scientific inquiry. If the answer to this question is prima facie found to be in affirmative, the stage for considering the operation of section 300 IPC is reached. But if suppose 300 is not now applicable, let us say, is reached, this is the stage at which court should determine whether the facts proved by the prosecution bring the case within any of the 4 clauses of the definition of murder contained in section 300. If the answer to this question is in the negative, it falls in 299 but does not fall in 300, it goes back as culpable homicide not amounting to murder, depending upon whether it falls in A, B or C,
299.
1 or 304 part 2. Am I clear?
Yes, sir.
Then I can come further. If the answer to this question is negative, the offense would be culpable homicide not amounting to murder, punishable under the first or the second part of 304, depending respectively whether the second or third clause of 299 is applicable. If this question is found to be in positive, yes, it falls in 299. It also falls in 300. We still cannot stop because we still have to examine whether it falls in any of the exceptions to section 300. If it falls in any of the exceptions to section 300, it goes back as culpable homicide not amounting to murder. But if it does not fall in any of the exceptions to section 300, it becomes punishable under section 302 as culpable homicide amounting to murder. Am I clear to you or not? Then the court says, if the question is found to be in positive, but the case comes in any of the exceptions in section 300, the offense would be culpable homicide not amounting to murder, punishable in first part of section 300. But if the answer is negative, it becomes culpable homicide amounting to murder, punishable under section 302. Am I clear to you? That is what I just wanted to say. And I will only do 2 exceptions. Because Justice Nagamuthu last time dealt with them very quickly. I will just take another 10 minutes because there came something which was not covered last time. You see, in Nanavati's case, the prosecution wanted to build up a defense. Now that is what I want you to emphasize. That's why I'm taking that part again. Prosecution wanted to take a defense even if there was a intervention of time in between and the person had regained the power of self-control. But subsequent provocation coupled with the previous state of mind can give rise to a new provocation. Let me illustrate it. I'll give you only 2 illustrations. A, after working for the day, reaches home and he finds his wife in an adulterous act with B. Then a reasonable man does nothing. Reprimands his wife and does not do anything beyond that. But next day, he finds his wife eating food on a village chopal with him, who is his worst enemy. This is what we call as revival of provocation. Keeping in mind the previous mental baggage. I am not giving you hypothetical illustrations. I am giving you illustrations from Nanavati's case itself. And that is what I just wanted to take up for the purposes of this discussion. I'll just give me 1 minute because this is something which I wanted to. This is Boya Munigadu versus Queen. It is your Madras case. I am only referring to what Nanavati's case Justice Subbarao has referred to. I'll just read it out to you. The accused saw the deceased when she had cohabitation with his bitter enemy. That night he had no meals. Next morning, he went to his work to get his wages. And at that time, he saw his wife eating food. Along with her paramour, he killed the paramour with a bill hook. The learned judge held that accused had sufficient provocation to bring the case within the first exception to section. Judge observed, now this is what I want to read out to you. In having witnessed the act of adultery, he connected his subsequent conduct as he could not fail to connect it. It would be conduct of a character highly exasperating to him, implying as it must that all conceived regards of his feelings were abundant and that they proposed continuing their course of conduct in the house This we think amounted to provocation, grave enough and sudden enough to deprive him of his self-control and reduce the offense from murder to culpable homicide, not amounting to murder. Another case. The case illustrates that the state of mind of the accused, having regard to the earlier conduct of the deceased, consideration in considering whether the subsequent act would be sufficient provocation to bring the case within the exception. Another division bench of the Madras High Court itself. Now these are all Madras cases. I am not going to North Indian cases. I am talking about Madras cases. And approved by Supreme Court. Approved because, you know, there are customs which vary. There are feelings which vary. There may be things which may vary. Justice Nagamuthu, welcome to the last phase of this talk.
No, I've been here. I've been
He was
right
here,
from the
but
beginning.
he was not showing his face. I mean, he was incognito.
Am I clear to you or not?
Very
Please
clear.
understand me. Another division bench of Madras High Court in Murugan held that where the deceased not only committed adultery, but later on swore openly in the face of the husband that she would persist in such adultery, and also abused the husband for remonstrating against such conduct, the case was covered by the first exception to Section 300. The Andhra Pradesh High Court in Re C. Narayan adopted the same reasoning in a case where they accused a young man who had a lurking suspicion of the conduct of his wife, who newly joined him, was confronted with the confession of illicit intimacy with and subsequent pregnancy by another strangled his wife to death, held the case was covered by exception 1. Only that what I am trying to say, previous mental background coupled with the independently as serious as to give rise to defense under exception 1, but when coupled with the previous mental background, it can give rise. I'll give you another example. Babulal versus State is a Allahabad case, AIR 1960, Allahabad 233. The appellant who came to reside in a government house orchard after seeing his wife having adulterous act with a person and left the village and went away to a different place so that he does not have this experience again and she is away from the shadow of this man. But one day, he found when he was coming back home that this man was leaving his house. Previous mental background, subsequent conduct gives rise to grave and sudden provocation. And I want to read out to you. The appellant, when he came to reside, where the husband who saw his wife in a compromising position with the deceased killed the later subsequently when the deceased came in his absence to his house in another village to which he had moved. The appellant, when he came to reside in the government house orchard, felt that he had removed his wife from the influence of the deceased. Hello, are you getting my voice?
Yes.
Absolutely, sir. That was Supriya just unmuting. It's okay. Correct.
The appellant, when he came to reside in the government house orchard, found that he had removed his wife from the influence of the deceased. There was no more any control between them. He had lulled himself into false safety. This belief was shattered when he found the deceased as his hut when he was at his hut when he was absent. This could certainly give him a mental jolt, and at that this knowledge will come all of a sudden, it should be deemed to have given him a grave and sudden provocation. The fact that he had suspected this illicit intimacy on an occasion also will not alter the nature of the provocation and make it any less sudden. These are what the court has said. Then the defense which was tried to be built in Nanavati was They said, all right. About her illicit relationship with Ahuja. He wanted to ask Ahuja whether he was going to take care of his wife and children, and if he was satisfied with his answers, he would have left them to their own and would have committed suicide or something. He says when he entered his house room, he asked whether he is going to marry Sylvia and take care of his children. To this he said, I am not supposed to marry every woman I sleep with. And this gave rise to a subsequent provocation which was grave and sudden, but the Supreme Court did not accept this because it was not satisfied. It found that it was an afterthought. It was not what was the plea taken at earlier stage. Therefore, the court did not give him the benefit of other judgments that I relied upon. But principle of law is previous mental background, subsequent conduct can give rise to a new grave and sudden provocation, and that can be a complete defense so far as exception 1 is concerned, reducing culpable homicide amounting to murder to culpable homicide not amounting to murder. Now let me come summing up. And please, if you look at section 320, you see we have definition of hurt in section 319. It says whoever causes bodily pain, disease or bodily infirmity is said to have caused a hurt. Then we have grievous hurt in section 320. These are definition clauses. Please be clear. What is an offense is voluntarily causing of grievous hurt. What is offense is voluntarily causing of hurt. And voluntarily is defined in section 39. But before I go to section 39, let me give you section 308. Section 328. And one very important point that I want to make. Clause 8 of section 320 is a residuary clause. 1 to 7 is enumeration of the residuary clause covers any hurt which endangers human life. Very important. Now, what is endangering human life? For the purposes of voluntarily causing of grievous hurt. Endangering human life for the purposes of voluntarily causing of grievous hurt means is likely to cause a grievous hurt, but is possibly also causing death. This is a very important distinction that I wanted to make. Kindly look at section 39. And I want to make it clear because I want to draw a very important line so that you are able to see what is the science of Macaulay permitting the provisions of the IPC. Kindly look at section 39. A person is said to cause an effect. I said Newton's laws of motion. There's always cause and effect, causal factor, which must not be remote, which must be direct. Because we talk about direct causes. A person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it. He intended to cause a grievous hurt means he intended to cause, endanger human life. Am I clear to you or not? Voluntarily causing of grievous hurt. Voluntarily he causes whereby he intends to cause it, or by means which at the time employing those means he knew or had reason to believe to be likely to cause it. In the context of grievous hurt, it means intention to cause grievous hurt, which is likely to cause death, which is likely to cause grievous hurt, or knowledge that it is likely to endanger human life, that it is likely to cause grievous hurt, and also possibly resulting in death. Now that is where the distinction has to be done. A death necessarily does not mean culpable homicide. Causing of death necessarily does not mean culpable homicide. Even if I intend to cause a bodily injury and objectively it only results possibility of a death, it is not culpable homicide. It must be likely to cause death. Likely is a higher degree of probability ensuing than possibility. When we say negligence, rashness in negligence, we say rashness is common in 304A, rashness is in common 325, rashness is common in 299, rashness is common in 300. But what matters, the rashness of what kind we are talking about, rashness of what degree we are talking about. That's why we say, what is negligence? What is rashness? I think there is a definition given by Muhammad Hussein's case, which I have given to you. Supreme Court has given, I do not give a definition, but Supreme Court has given a definition in Muhammad Hussain case itself. The criminality rise. Now this is what I want to make 304A, the distinction is very clear conceptually. The criminality lies in such an act with recklessness or indifference to the consequences. Criminal negligence, on the other hand, is the gross and culpable neglect or failure to exercise that reasonable and proper care and precaution to guard against injury either to the public or individual, having regard to the circumstances, that it is imperative duty, rashness, that is not it, that death may result in the consequences. Now therefore, when it talks about consequences, that when we talk about is may, and when we talk about culpable homicide, we say likely, and when we talk about murder, we talk about more nature to cause death. Now this degree of culpability, degree of consequences ensuing is very important, which we cannot keep. That is why 39 talks about voluntarily is different from rashness or negligence, because knowledge, intention, knowledge of the likely consequence is what we call as voluntary. That is where we have to make a distinction between 325, 338, 337, 339. All these distinctions are very important. Now let me sum up to say that 299, 300 are to be talked about only when death has ensued. Every death does not mean culpable homicide. If it has to be tested on the anvils of section 299, as I said, Punaya's case, 3 stages to be talked about. If it does not fall in the definition of culpable homicide, you have to exercise other options available. If 299 is not applicable, you don't have to go to 300. But 300, you have to pass through 299. It must fall in 299. You have not to stop inquiry at 299. You have to compare the comparable clauses of section 300. Even if any of the exceptions to section 300 is applicable, if it is applicable, it still is culpable homicide, not amounting to murder. If it is not applicable, only then it is culpable homicide amounting to murder. So therefore, as a common man, if I am asked to sum up what is culpable homicide and what is culpable homicide amounting, not amounting to murder, I say culpable homicide amounting to murder means if a death has happened and the case falls in 299 and also falls in 300, it is not falling in any of the exceptions. We say culpable homicide amounting to murder. What is culpable homicide not amounting to murder? A case which falls in 299 but does not fall in 300, or a case falls in 299, falls in 300, and also falls in one of the exceptions to section 300. Thank you very much.
Sir, I don't know what to say. I'll leave it to Justice K.T. Shekaran sir to start off. Then we'll come to Ram Kumar sir and.
Question.
Now, Justice Ram Kumar is the right person.
Oh no, certainly. Come in. Okay.
I
that,
will only say thank you, sir.
brother, before that, let us all thank him again.
Thank you very
Before
much.
that, brother,
I am a civil man, not a criminal man. Ram Kumar is.
we refuse to
And
get
Justice
civilized.
Nagamuthu is here. They will
brother,
comment.
I want one clarity from Professor Kaur.
Okay.
May I ask, brother, with your permission, may I ask one thing to him?
Yes.
Okay.
Definitely.
Professor, you remember that case which I authored, heading the division bench, Ganesan versus State.
Yeah.
And in that case, I very clearly stated that first of all, it is.
We're not getting it. Yeah.
You are not able to hear me. Okay. Now, are you able to hear me now?
That's far better.
Much better. You're always very clear.
So I authored one judgment by Ganesan versus State, where I referring to this Rayavarapu Punnaya and this Birsa Singh and all the other cases. I also said the same thing. It was in a very simple terms. I given explanations also. The first, it has to be tested with respect to 299. Then we have to go to 300. Then we have to go to the exception. All this is all right. Now, so far as class 2 of 300, secondly of 300, and the second limb of 299, you said that we have to read the illustration 1.
Explanation 1.
I'm sorry, explanation 1. Into that to know, so to bring the same under 299, then to take it to 300. Very good.
No, I did not say that. I said I will read because we have started with the premise that first 299 must be applicable before you go to 300.
Suppose, see, Professor, here is the problem. See, suppose here is a man who is suffering from some kind of disease. Okay? The accused knows that he is suffering from that disease and causes that particular injury which he intended.
Yeah.
Man dies. So here, if suppose the same injury is caused to anybody else with ordinary health,
Yes.
that would not occur. Okay? First of all, you have to bring it under 299 too.
299B.
290, yes, second. Where you have to bring it first. Further, in order to understand that, you wanted us to read this explanation 1. Okay?
And implicit knowledge.
Okay.
So, and implicit knowledge.
If this explanation is not there, it will be very difficult to bring it within the second limb of 299. Correct?
Yes.
Very good. Now let us go to 300. There is no such illustration given to 300. 300, Professor, please kindly see fourthly of 300. Please kindly see.
You see, whole rot.
Fourthly.
I'll just say. Let me say.
I will read it
before I know what you're asking. I know. The whole rot has come from this illustration, because the illustration should have been worded like this: not sufficient to cause death.
Yes.
Or sufficient to cause death of a person of normal health. Kindly see, knowing that Zat is laboring.
No, I am not there, Professor. I am not
likely to cause his death, strikes him with the intention of causing bodily injury. Zat dies in consequence, right?
Professor, regarding that, I got no doubt. Please, there is no doubt.
No, I'm only. Just let me read it. Let me read it out to you. Let me read it out to you. A is guilty of murder.
Yes.
It has to fall in 299, it has to fall in 300, right?
Very good.
Where it is wrong. Though, because 299 class 2 does not say sufficient to cause death.
Yes.
It says likely to cause death. It should have said, though it is not sufficient, is not likely to cause death of a person of normal health. But anyway, is not sufficient to cause the ordinary course of nature sounds stereo. Knowing, now you give me that. Now come to that.
No, I'm not on this. Professor, I got no doubt about that. So I am very clear in my thinking regarding this second limb of 299 and secondly and thirdly of 300, I got no doubt. Now I am on fourthly of 300.
Yes.
Fourthly, I will read fourthly. If a person committing the act knows, so you are attributing knowledge to the person. What is that knowledge? That it is so imminently dangerous. What is imminently dangerous? His act is so imminently dangerous. Okay. That it must, in all probability, cause the death. Stop here. So you are attributing knowledge to him.
No, he ought to know. Like I gave the Chandrasen case.
Let me complete, then you please explain. Please explain. If a person committing the act knows, the person should have committed an act, he should have knowledge. What is that knowledge? That his act is so imminently dangerous. Not only that, not stopping with that, that it must in all probability cause the death. So to that extent, you got to attribute knowledge to him. Okay. Now go to the next part. Or such bodily injury as is likely to cause death. So you have to read it like this. If I understood it correctly, if the person committing the act knows that his act is so imminently dangerous that it must in all probability cause such bodily injury as is likely to cause death. Okay. So if he has got knowledge that his act is likely to cause death, then his act will fall under limb 4.
Yes.
I'm sorry, fourthly. So there are two kinds of knowledge. One, knowledge that his act is likely, his act is so imminently dangerous to cause the death. Two, his act, his knowledge that such bodily injury as is likely to cause death. His act will result in such bodily injury as is likely to cause death. This is second part. Now you come to 299. Where will you fit in this? Such bodily injury as is likely to cause death. 299 limb 3, you go to 299 limb 3. Where will you? But first of all, we have to start from 299. So knowledge, so far as knowledge for the purpose of 299 is concerned, with the knowledge that he is likely by such act to cause the death. But not the knowledge is not to cause bodily injury, which is likely to cause death. So,
you see,
so far as 304 is fourthly is concerned, regarding this part, such bodily injury is likely to cause death, you have to first of all fit in limb 3 of 299. How to fit in? Please
let us look at E.K. Chandra Senan versus State of Kerala.
Which tragedy?
On Onam Day,
Piping.
you have to sell local liquor to the people. You mix in it methyl alcohol of the proportion equivalent to 80 to 95%, which is a deadly poison. What is the knowledge attributable to you?
You will result in death.
Let us say likely to cause death.
Imminently dangerous.
Let us first go to 299C. 299C is satisfied. Correct? Now let us go to the fourthly. It is not only likely to cause death. It is a knowledge of the highest degree. Imminently dangerous act. You see, fourthly has two parts.
Professor,
One,
I think I have not made myself clear in my question.
no, you have made yourself very clear.
There are
You see, what is confusing
regarding
is
first part of
two limbs.
not difficulty at all. Regarding first part is knowledge that his act is imminently dangerous. Not only with that, and by all probability is likely to cause death. So higher degree of knowledge. His knowledge is that his act will result in death. Put it in simple words. Death is imminent. I have the knowledge. I do the act. 304 comes. Second part. You please kindly come to second part. Regarding first part, I got no difficulty at all. My knowledge is of such a higher degree that my act is so imminently dangerous and it will also result in death. Regarding that, you come to, regarding this part, I got no difficulty. Come to second part. Or such bodily injury as is likely to cause death.
And you have to read first part along with it. In all probability is common.
Yes.
In all probability is common.
In all probability.
In all probability, imminently dangerous act in all.
No, imminent. See, in all probabilities.
So you have to read it different from class B up to 99.
Professor.
But second, there is no, for second to get attracted, there should be intention, not knowledge.
No, he's
This also knowledge. This also knowledge.
I mean, thirdly.
You know, he's coming to fourthly. He's dealing with fourthly.
Fourthly knowledge. No, he is comparing it with secondly, is it not? Thirdly
of 299.
You see, he says.
Thirdly of 299. Yes.
He says. Now let me first say what I say, and then let us see. He is dealing with two parts of fourthly. Causes death or such bodily injury as is likely to cause death. Imminently dangerous in all probability is common.
Yes.
Is common. Knowledge that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death.
Professor?
No, according to you, clause 3, thirdly is not.
He's not dealing with, he's dealing with fourthly.
I'm sorry. According to him, clause C of 299 is not wide enough to take in clause fourthly.
No,
that is what is. It is not.
My point is, Professor. So one second. I will explain as to what is there in my mind. I will explain first.
Okay, please.
Professor was right in saying that first of all, you should be a homicide, culpable homicide falling under any one of the three limbs of 299.
Yes.
If let us say that it falls under limb 3 of 299,
yes,
then the further inquiry is whether it falls under limb 4 of 300. If it falls under limb 4 of 300, then we have to test whether it falls under any one of the exceptions.
Yes.
These are the related provisions. Okay. Now, my point is, please come to 300 fourthly. There is some difficulty for me even now to understand.
Yes.
If you come to 300 fourthly, if the person committing the act knows, so let us say that I am doing an act. I know. What should I know? I know that it is so imminently dangerous. That is, my act is so imminently dangerous. Number one. Number two, not only with that, and you see the conjunction, and the bodily injury. I'm sorry.
It must in all probability.
It must in all probability.
In all probability,
cause such bodily injury.
Cause death. Stop there. That is or cause the death. So I should do an act. I should have knowledge. What is that knowledge? My act is so imminently dangerous, and by all probability, it will cause death.
Regarding such bodily injury,
cause the death. There is no difficulty in that. Now come to the next part. Next part. Or such bodily injury. How this is to be read according to Professor and according to me also, if the person committing the act knows that it is so imminently dangerous, it is dangerous, it must in all probability cause, you see the comma, it is not cause such bodily injury. Comma is before cause the death and after cause the death. So if you have to read this imminently dangerous, that it must, in all probability, or such bodily injury, doesn't make any sense at all.
Why not?
You see, comma is there. Comma is before cause the death.
It must in all probability cause such bodily injury as is likely to cause death.
Cause is there. See, comma is there before there. Cause death is one phrase. Cause death is one phrase.
Cause death or
No, it is
or.
Cause, there is no comma before death.
Are you saying that cause is qualified? Death alone is qualified by cause.
Cause is common to both.
Please wait, Professor. Cause death or bodily injury?
Yeah, no
Cause
problem.
death or bodily injury?
Yeah.
You are saying that?
Yeah.
Very good. That's what I am trying to say.
Cause is common for both.
Cause death or bodily injury.
Yes.
Bodily
Cause is common for both.
Therefore, I should have knowledge that my act.
You will be attributed with the knowledge.
Please wait. My act will cause bodily injury, which is likely to cause death.
Yes.
Second part.
Yes.
So I want to repeat. So I have knowledge that my act will cause bodily injury, which is likely to cause death. Is it not?
Yes.
Second part. Then imminently dangerous, everything is applicable.
Okay.
Now you go to 299 limb 3. Where do you get likely to cause death?
Likely to cause death is supplied by explanation 1. Is supplied by explanation.
You see, the nature of the act is
293. 293.
Brother, it is supplied by explanation 1.
No, that is explanation 1 is relating to limb 2 of 299, not 3.
Not only.
Yes, that is intention.
Not merely intention.
No,
A person who causes bodily injury to another, who is laboring under a disorder or disease or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused the death.
But this is special knowledge in respect of the peculiar health condition of that person.
Yes.
This is relatable to 302, not here.
Yes.
Now here, my point is, so first of all, we have to, suppose I have the knowledge that my act is likely to cause injury, which is likely to cause death.
Yes.
290 limb 3, knowledge, 290 limb 3 alone speaks of knowledge. This speaks only of my knowledge that my act is likely to cause death. 290 limb 3 speaks.
Father jumps into the well along with the child. What is the knowledge attributable?
Wait, Professor. 1 second. Knowledge that is likely by such act to cause the death is there. Now, whereas 300 limb 4, fourthly, contains 2. 1, knowledge that I am like that imminently dangerous, that my act will result in death. Second part, likely to cause death, injury. My knowledge is that I will cause injury. That is likely to cause death.
Likely to cause death is supplied by illustration 1.
That is objective, brother. Second part is objective. Whether it is likely or sufficient is objective test. First part is my knowledge. My knowledge is that I will cause an injury.
Explanation 1 supplies likely to cause death as accelerating the infirmity also.
Yes.
Limb 4 of 300
yes,
has got nothing to do with the special health condition of the deceased. It is different.
All right.
There is some problem. Please, Professor, you also please kindly consider how to bring it. See, so far as limb, Professor, so far limb.
No, we'll consider. I know there is many people have this this difficulty. Many people have in understanding class 4.3.
Professor,
this is not. This
I am
is
saying,
concern,
see, you are.
a concern.
See, you are perfectly right in saying that illustration, the illustration gives an idea to bring the special knowledge within 299B. Okay, 299B. But so far 219C and the second part of fourthly, there is some difficulty. There is no illustration given even.
Yes, yeah. No, you look at last illustration to section 300.
Yes, take that.
Look at last illustration to section 300. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them.
Yes,
A is guilty of murder, although he may not have had a premeditated design to kill any particular.
299. Where is the explanation? 299. I am asking that. 300 comes under 300. No difficulty. It is to be brought under 299.
Justice Nagamuthu,
Yes, sir. It's not
may I
there.
intervene?
It's not.
Intervene.
299 and 343 part can't be.
Mr. John Ralph.
It's missing there.
Mr. John Ralph,
Let
would you
us
like to comment on it?
let us take other. Yeah.
Would you like to comment on this topic?
Yes, sir. The doubt is being raised by Nagamuthu sir is a very crucial thing. It is not being dealt with in the explanation one. It is not.
You explain. In your own words, you explain.
No, I cannot explain, sir. It is a very difficult thing. I'm always confused on this aspect. I just want to ask somebody.
Brother, I want to tell you that
Nagamuthu sir,
I am
can you
laboring
please?
so much to find some solution to this. I don't find any judgment at all.
Nagamuthu sir,
This thing is
Nagamuthu sir,
absent.
can you
Sir,
please?
be silent on this.
I see. Just
No, sir,
on
Versa
first
decided on-
principles on reading 299 and 300. What, without any discussion, what is John Ralph your understanding of the problem which is now raised by Justice Nagamuthu?
Me.
Ah,
I cannot answer, sir. I cannot
he
answer.
says that he cannot answer.
I cannot answer.
As
I'm confused.
the other friend said, I am also laboring a lot to find a solution to this.
Likely, but
I
check.
don't find any judgment at all so far. No, nobody can answer this query, I tell you.
Likely to cause death and likely to cause bodily injury. According to you, likely to cause bodily injury is not taken in by likely to cause death.
One person is there who can be asked, but not now. Justice UL.
Prem, what do you say, Mr. Prem? Prem Raj?
Prem is there?
Yeah.
Prem, yeah.
Actually, I feel that it is taken in the 299 itself. How could you say that fourthly that cannot be a part of 299? 299 doesn't take in that particular fourth portion of 300.
No, it takes into account.
It takes
It
in.
has to be done.
Only
If it
question
doesn't
is.
come under 299,
No,
won't go to
it
the-
only says that a higher degree of knowledge. Higher
Exactly.
degree, in all probability.
The knowledge that it is likely to cause bodily injury is not absent. Is absent in clause
That
C.
is no, not absent. How to read this?
But I think
It is very
according
clear.
to
See,
me, according
if
to
the
me, explanation
person-
one will supply that.
yeah, because if the person who commits that particular act knows that it is
It's not a
imminently
question of his
dangerous.
knowing. It's not question of his knowing. It's a
Ah.
question of how much knowledge can be attributed to it.
Exactly. If he knows that it is imminently dangerous, that it must in all probability cause the death, right?
Or such bodily injury as-
Or that such bodily injury as is likely to cause death,
Yes.
and commits that particular act without any, excuse, as Professor Kaul has pointed out by way of illustration 4, without any excuse for incurring the risk.
Brother, this excuse is common to both the classes. Okay?
Yes, exactly.
Let us
Excuse,
have other questions also.
absence of excuse is common to both the parts.
No,
of-
if
No doubt about
that particular thing is read this way, it takes in 299 clearly takes in.
I will discuss this question separately with Justice Nagamuthu. Let us take other questions now.
They will have discussion. They will have detailed discussion.
Yeah, detailed discussion.
And please,
The
please
beauty
reveal
of
please
Reveal
reveal
the
to us
result.
the result of your discussion.
I put that question.
I'll let
to
him know. I'll let him know.
Bhushan sir.
it needs further discussion also. It's not that easy.
Kaul sir, I put this question to Advocate John Ralph because he is experienced in
Criminal
conducting
lawyer.
several murder cases. And he also writes articles. He seriously studies the subject.
All right.
That is why I put that question. He confessed that it is a difficult question as
difficult
Justice
question to
Nagamuthu
answer.
put it. Now, anyhow, you resolve it and find out a solution. And inform us.
the beauty of our sessions is that we crop questions, propositions which requires further deliberation.
And we are not inhibited by case law.
Any
We are not inhibited by.
case law is only to assist.
Always we go by the first principle.
That's all.
Correct. Now, anyhow, Justice Nagamuthu, you have put a question that created so much of difficulty to
There is a point in what he says. But according to me, that is supplied by explanation one.
No, professor was very clever enough to say that what is 2 of limb B of 299, what is missing in limb 2 can be understood by reading the illustration. But unfortunately for professor, there is no such illustration given for this.
Now, I have got a doubt. I see my limited knowledge in criminal law, you all know. My doubt is this. Can you import the illustration to this interpretation?
That is another question.
Yeah.
That is another question. Very interesting question.
Illustration is only illustration.
Correct. That is
Can
the
you have that illustration for the purpose of the interpretation which you have placed with respect to the clause 4.3 in 302 and clause C in 299?
absolutely correct.
Illustration
Cannot form part of the main clause.
takes in only one part of clause 4.3, causing death, not causing bodily injury.
Ah, that is right.
Exactly.
So can the illustration be taken as an aid to interpretation?
Yeah. It's very well established.
But
Principle,
if we
it's an internal aid.
That is true. But when this deadlock is there, as pointed out by Justice Nagamatu, my doubt is whether that illustration would clear it.
Yes.
Or the interpretation has to be made on the basis of the wording itself.
No, if you can find from the wording, that is fine. But sometimes aids have to be taken. And it's an internal aid, is a part of the statute. And what are the illustrations? They're all English cases decided by the English courts.
Professor, one doubt that is lingering in the mind of the younger generation, and of course all of us, is that can the illustration outweigh the wording in the provision, main provision?
Sometimes what happens is although you call it illustration, but sometimes the courts read illustration as a operating
main
part
provision.
of the statute.
Correct, sir.
Professor, can I raise a doubt? Professor, can I raise a small doubt?
Yeah.
Professor, you are on explanation 1. To understand the clause 2 of section 300. But the explanation 1 says about accelerates death. Accelerates death. So many experts say that it is to prevent a case of euthanasia. Because of the word accelerates death. What is your opinion about it?
No, euthanasia is altogether a different ball game, because you see, euthanasia is active euthanasia and passive euthanasia. Active euthanasia is always punishable, Whereas we have, to some extent, in common cause case, now also as a member of the ICM, we have come out with the do not attempt resuscitation. So those have come, but I don't think it has anything to do, except that it says that, some people may say that, no, he died because he had a bad liver, he had a bad spleen.
Proximate cause.
If you accelerated the death, that is also causing of death. So
that is proximate cause.
That is what explanation 1 says.
So the doubt stems from the fact that somebody has to die if he is sustained on certain.
There may be a person who is terminally ill, and he says that I want to die, and doctor give me some medicine. Or give me some injection. That will be culpable homicide, not amounting to murder, because consent, exception 5 to section 300, you will always find as a culpable homicide, not amounting to murder.
Sir, in view of the recent authentication in 2018 by the Supreme Court of living will,
it's a very cumbersome procedure. You have to follow that procedure. Only then you can, you will die before you are given permission to die.
That of course, sir. In Bombay case, we have seen that.
But we have come out with a new ICMR guidelines, which has been published in the Journal of ICMR. I was a member of that national committee.
But Corona has outbeaten all these things.
Yeah, I think so.
299, 300, 304, everything.
Any other query, Mr.
Yes. Before we go further, we have, I think, the person's Sundar Mohan. Sundar Mohan, can you just put your question?
Yes.
Yeah.
Professor Kaul,
yeah.
Sir, can you hear me?
Yeah, I can hear you.
Sir, you said about section 80.
Section 80.
80, yes.
Yeah.
So it talks about 6 conditions. May I read section 80, sir?
Yes, yes.
Nothing is an offense which is done by accident or misfortune. That's the first condition. And without any criminal intention or knowledge, second condition. In doing of a lawful act, third. Lawful manner, fourth. Lawful means, fifth. And with proper care and caution. No, sir. Any offense, if there is no intention or knowledge, it's not an offense. Any act without intention or knowledge, it's not an offense. Then don't you think the other 5 conditions are redundant?
No, they say either or. Read 80. I think we must read 80.
Yes.
That's why I want to make it.
In any case, if there's no intention or knowledge.
No, kindly say, and without any criminal intention.
Yes, sir.
Or knowledge in doing of a lawful act in a lawful manner by lawful means.
Yes.
And with proper care and caution. No, knowledge, you see, rashness.
Except for rashness and negligence, all other offenses have these 2 mental states, either one of these. So the moment I establish there's no intention or knowledge, the offense goes, that does not become an offense. Then why these other 5 conditions, sir?
No. It is only to show absence of any form of guilty mind. Mere, you see, suppose I am driving in a proper manner, in a proper road with the proper vehicle.
Correct.
Somebody jumps before my vehicle.
Yes.
He wants to commit suicide.
Yes.
Now he is hit.
Yes.
Tomorrow you will bring a case against me for endangering his life.
Yes.
Now can I be held liable? If I have followed all care and caution and walked within the permissible limits, we can call it pure accident or what you call anything else in that. Yes. So that position is very clear. That please do not haul up those people whose acts are pure misfortune and accident.
Yes, I agree.
It is to make it very clear, like triviality.
That illustration clears, very clear illustration.
Section 95, triviality. Hammer. Now I take up I take up 2 rupees note from your desk.
Yes.
Now tomorrow you bring a FIR against me because I have taken 2 rupees. Now is it not a trivial?
De minimis.
Sir, I follow that. My only doubt is, suppose in a case I am able to show that there is no intention or knowledge. Isn't it good enough? Should I show misfortune, accident, lawful manner or lawful means?
This is what I was trying to say.
Yes.
Look here. Suppose a person dies.
Yes.
By your act.
Yes.
Now they say 299.
Yes.
I say no intention, no knowledge.
Correct.
They say come to 304A.
I agree with 304A. That's a different state.
I say 304A now. You cannot hold inquiry there also. Yes. Now you come to grievous hurt, endangering life. You cannot apply there also. So my act is a case of an accident or misfortune. Death is not, mere causing of death is not an offense. Death accompanied by act, accompanied by any form of guilty mind.
Yes.
Whether it is in the form of intention, knowledge, rashness, or negligence.
Want of due care and caution.
Yes. Yes. Thank you, sir. Thank you.
Thank you.
Yeah. Thank you, Sundar.
Yes.
I think nobody has put the hands up. I think the class.
Yes, Shanti did it.
Sir?
Shanti. Raised her hand.
Shanti, please, if you have.
Vanished.
Professor.
Yes, sir.
Professor, I got one small.
I have so many doubts.
Your doubt is always small, but very big.
Experience. In your rich experience.
Tell me, sir.
Is it true that in every case authored by the Supreme Court, that all these tests, both subjective as well as objective tests, are conducted?
Except in, sorry?
I do not see in many judgments whether it falls under 219 which limb, and then under 300 under which limb, and whether it falls under any of the exception, which exception or no exception. 105 of the Evidence Act says that the absence of the exception is the presumption. Okay. Therefore, unless a plea is taken, that it, for his act falls under any one of the exceptions, then he need not, you need not go into that at all. But anyhow, the judgment should say that the act of the accused falls under limb 1 or 2 or 3 of 299. And it also falls, we have further tested. Yes, it falls under limb 3. Whether it is done.
It is because of this reason only, we always say Virsa Singh is a locus classicus. Punaya is a legal classicus. Because there the judges have taken pains to say which clause of 299, which clause of 300, which exception is not applicable. It is only these judgments. There are books and books. Books for all times and books for time only. Most of the judgments are books for time only. There are only few judgments which are books for all times. That is my answer to you.
Yeah, many judgments are really disturbing.
Very disturbing, very disturbing.
Yes.
Sir, Abdul Kader has put a question, or rather made a statement. Abdul Kader, can you just come forward and put it?
Sir, my question was, as regards section 18, to beat an accident, that act must be done without any. Sir. To beat an accident, it must be done without any criminal intention or knowledge, in the doing of a lawful act in a lawful manner by lawful means and with the proper care and caution. Suppose a person drives a vehicle without driving license. Can it be termed as doing that act in an unlawful means?
Justice,
in an unlawful manner. So as to oust that matter out of accident.
Justice Nagamuthu can answer this question. You see, these are two separate offenses.
So you please read the judgment in BMW's case of the Supreme Court.
Yeah. No, I think other aspect is also not having a license is a separate offense. Criminality of a person has to be determined, though presumption may be more against him. It has to be determined with respect to whether he was a person who could drive and had the sufficient knowledge about driving, and whether he was tested for driving, and whether therefore he lacked in care and caution. So that will be a test which has to be applied in that case.
Professor, it is more or less like saying a thief saying that I have committed theft, but it's black money which I have taken. So you cannot.
No, I think standards of IPC have to be applied. Negligence and rashness has to be seen. But then when a person drives without a license and whether it's competence to drive, presumptions will be always against him only.
Professor, what is your view about the Bhopal tragedy case? Whether it will fall under...
I thought it was 304 part 2 at least. I am very clear on that part.
Yes. But...
I think it was that charge was diluted subsequently by the Supreme Court, and there was so much. I think that is still pending before the Supreme Court. Review of that judgment is still pending before the Supreme Court.
Ralph, I'm sorry, sir. Please.
Please go ahead, please.
Ralph, anything to be commented upon, or you want to put a question?
Well, yes, a doubt.
Nothing.
Okay, over to Prem.
I just want to add one thing, sir. Professor, you said while reading section 304th, you said without any excuse. And you said without any excuse applies to general exceptions or special exceptions.
No. I said this is independent of the general exceptions and also partial defenses.
Okay, sir.
I said this may not be exactly a legal defense, but it is something what the circumstances prove are factors to be taken into account so as to make it excusable, independent of the defenses available under the IPC. It's a requirement of law.
Can it be also a case of self-preservation?
That is then self-defense. That is the right of private defense.
Self-preservation.
What is self-preservation? Right of private defense only.
No, sir. As in the case of a problem
Dudley versus Stevens.
Yes, sir.
That is in the law of torts.
They did not accept that.
Yeah, Prem.
Yes, sir. Actually, I'm dearth of words what to say about Professor Cowell's unparalleled academic brilliance. And today, the talk, I would say it was really sequentially very smooth and the distinction of 299 and 300. It was drawn in with the most minutest of abstractions, really amplifying the scope of those two sections. And I think everybody would agree if I would say that it was boundless pedagogical skills were displayed with perceptive clarification. Hats off to you, sir. Really.
Thank you very much.
And sir, I would just like to know one thing. You said about the snake charmers case also.
Huh.
Right. That also, I think, was an English case. Gunesh
Yeah, it was an English case.
Right.
That's true. That's true.
Thank you, sir.
It's one of the English cases decided. That's why I picked up that illustration to show no intention to kill, no intention to cause bodily injury, but dangerous act, which is likely to result in death, and death results. You cannot say, I did not know it. I did not know it's a... You ought to know if you have not removed the fangs of the snake.
But sir, at the same time, suppose with the snake charmer, guess that there was another person also, his helper or something, any person who is helping him. He has a lesser part because it is a snake charmer who invites that particular person, come on, play with the snake and all. Suppose if any other person who is aiding the snake charmer, what would be the offense he is committing?
I'll give you a small illustration. There is a person. Somebody wants to befriend a girl.
Okay.
And then there is no doctor or there is no registered medical practitioner. But somebody has a reputation that he gives. Some love charm which you give to the girl, she will start befriending you, you know. And that turns out to be very deadly for the, you know, for the girl. She dies. And can this boy say, I did not want, I should not be held guilty. That man gave it to me. You are giving it without verifying the contents you are giving to this girl. There you are culpable negligence. So therefore, can you escape the liability in that case? No.
Sure.
You will be liable.
True. Thank you so much, sir. Thank you so much.
Thank you, sir. Thank you for that.
That is why you must be giving medicines only on the registered medical practitioners authorization.
I would like to,
Sir, before we that was a wonderful example, sir. I mean,
Thank you, sir. Thank you very much.
I would like to add.
Yeah.
Now this is a 2 hour and odd business. We had a
So almost 3 hours.
we had a discussion for more than 5 hours in the National Judicial Academy, the Kerala Judicial Academy.
Yeah.
And one thing which is different in the direct interaction in a classroom and a Zoom
virtual conference.
So, there is a lot of difference. And after hearing him for about 4 or 5 hours or more, I noticed one thing, that Professor Cowell's voice modulation. I identified 6 types of voice modulation. Something high pitch goes down, down, down. And I told him, he just laughed.
From hurt to murder.
Depression.
From simple hurt to murder.
See,
Assault to murder.
See, just lecturing in a classroom with this type of person who is highly knowledgeable and who has got a skill to impress the audience. That voice modulation gives so much of power. We have experienced it. But this is not a substitute, this medium. Sir, we are very, very thankful to you. You must
Thank you very
visit
much.
Kerala again and again,
Yeah, thank you very much.
Come to South, why do you call him to Kerala alone, to South?
We fall in the same category, sir. It's South India.
I took him to Madurai. He stayed there for 2 days continuously, and he did wonderful service. And we invited him on many occasions to our Tamil Nadu Judicial Academy. and he also reads all our judgments. And in that Ganesan case which I wrote, he went through the judgment. When I spoke to him, he said that there is an error in your judgment. The clerical error, he noticed that
information.
At one place, instead of saying that, I concluded that therefore it is homicide. But there is a clerical error, it is culpable homicide. Then I started discussing whether it is culpable or not. So the discussion started thereafter. A clerical mistake. He noticed that.
Though I practiced on the civil side, and though a civil man, but for about 5 years I was hearing murder cases and rape cases. And then I had occasion to render so many judgments. I do not know whether Ram Kumar will say that all foolish, but on one occasion I had to say what is the interpretation of 299, 300. In these words I did it. It is 299, any of the 4 clauses in 300, it goes to 302. If any of the exceptions come, it goes to 304. Sir, is it correct?
Correct.
Correct. Very correct.
I relied on Versasi.
Thank you, Professor. Thank you.
This brings us to the end or culmination of the 42nd session. The lockdown period has been very fruitful with faculties and eminent persons addressing us, sharing of ideas and propping up questions and propositions which requires addressing properly, which we intend to take up in the long run. Not that the lockdown should go on indefinitely, but still we'll keep this running. Today, I'm indeed indebted to Nagamuthu sir firstly for introducing Kalsar when you addressed us the other day, and Shankaran sir for having given me the liberty to directly contact Kalsar and ask him to be a faculty today. Ramkumar sir for being the creative and inputs that has come in, and each and
What
every
happened to Asaf Ali? What happened to Asaf Ali?
Sir is here, I believe. Yeah, he had joined. 1 second. Sir, Asaf Ali sir, are you here? He had given me a message that he has joined because Kalsar wanted, and I did intimate him. I hope he is here.
Okay.
Fine. So, tomorrow in the 43rd session, we'll be dealing with wills. Leading the deliberations would be Advocate P.T. Mohan Kumar sir, and Justice Shashidharan Nambiar has agreed to be the moderator tomorrow.
Very good.
So we'll all meet again tomorrow on a wonderful session on the law of wills, whether one should die willingly or unwillingly. We'll decide tomorrow. So thank you very much.
Thank you.
Please stay safe. Take care. Till we
Sir.
meet tomorrow.
Sir.
Thank you very much, Kalsar, once again.
Sir,
Yeah.
good evening, sir. I have one question regarding the yesterday's session. Can I ask?
Sure, shoot.
Good evening, everyone. Sorry to interrupt. Actually, I have a question regarding yesterday's session. I'm audible, sir?
You're more than audible. Please go ahead.
Okay, sir. Sir, this is a question was, agreement for sale is duly registered, and within a period, the party has also executed the sale deed with respect to that AGS, with reference to AGS. But in some circumstances happened that
What is AGS?
Hello?
What is AGS?
Agreement for sale, sir.
Okay, I'd like to know the short form. So, yeah, good.
Agreement for sale.
Yeah.
But in some circumstances happened.
Yeah, sure, sir. Yeah, please.
Thank you.
Thank you, sir.
Yeah.
Sir, agreement for sale is duly registered, and within a period, the party has executed sale deed with respect to agreement for sale, with refer to AGS. But in some circumstances happened, the dispute arised between the parties, and one party has given the notice and terminated the AGS. But in the AGS, there is a clause mentioned, arbitration clause. But in supplementary agreement, the clause is not mentioned. My question is whether the aggrieved person can file a case against the arbitration in that court?
Anyway, the principal agreement contains an arbitration clause, right?
Yes, sir.
Subject to what Nagapathu sir and Shankaran sir has to add, but I'll just have a take on that. That is, you say that the original agreement to sell
Yes, sir.
Contains a arbitration clause.
Yes, sir.
And parties have invoked that.
Invoked that. Yes, sir. Terminated the agreement.
So what is the doubt?
But my question is whether the aggrieved party can file a case against with that supplementary agreement. They can take that supplementary agreement and can file a case in arbitration.
According to you, the original agreement to sell has been superseded by a supplementary agreement which does not contain an arbitration clause.
Yes, sir.
It's not substituting. It is only supplementary. There is no.
It's only supplementary. If it is supplementary, then whatever is there in the earlier, unless and until it is specifically excluded, will continue.
Both the documents are to be read together.
Together. Very true.
Correct. So if that be the case, if it is nomenclatured as supplementary agreement, and if this clause is not specifically excluded in the second one, to me,
yes,
and to my understanding, it has to continue.
Correct.
Oh, okay, fine.
And if you go for a civil suit, they will invoke section 8 and they will bring that, what do you call, exclusion and say that it has to go for arbitration. Of course, it has to be specifically raised. Otherwise, suit will continue.
Okay, sir. Okay.
Thank you.
Thank you, sir. Thank you so much. Thank you.
Thank you for that final interdict and interaction so that this makes our forum live and lively.
Thanks to you all people, sir. Thank you. Have a nice day, sir.
We'll meet again tomorrow, 3:30.
Yes, sir. Yes, sir.
Take care. Stay safe.
Thank you, sir. Thank you.